Okay, picture this. You are sitting in a courtroom. The air is, a little stale. The lights are buzzing with that low hum that kind of gives you a headache after 10 minutes. And the tension is just, it's so thick you could cut it with a knife.
Mm-hmm.
And then the prosecutor stands up. The whole room goes quiet. They walk over to the evidence table, very slow, very deliberate, and they pick up. Maybe it's a rusty revolver.
Or a bloody shirt sealed up in a plastic bag.
Exactly. Or a crumpled, coffee-stained contract that's worth millions of dollars. They turn to the jury, hold it up like a trophy, and you hear the jury just gasp. It's that moment, right? The smoking gun, the definitive proof.
It is. It's the moment everyone waits for in the movies. It's pretty much the climax of every single episode of Law & Order. But here's the reality check. In real life, you can't just walk in and, drop a gun on the judge's bench.
Not at all. You can't just say, hey, look what I found, and expect everyone, especially the jury, to just believe you. There's this whole invisible obstacle course that every single object has to run before it even sees the inside of a courtroom.
It's like a maze of rules and tests and hurdles and trapdoors.
And today, we are going to run that course.
We are. We're diving deep into the principles of tangible evidence and authentication. And I know that title, it sounds a little bit dry.
It sounds like the title of a textbook you'd use to prop up a wobbly table.
It does, but I promise you, this is actually one of the most fascinating parts of the legal system. We're drawing from some high-level bar review materials, specifically stuff on the federal rules of evidence, to really understand how the law decides what's real and, what's fake.
So this is about the epistemology of the courtroom. How do we know something is true?
That's a great way to put it.
We're basically going to decode the matrix. We're going to figure out how a lawyer proves that a text message is actually from you and not some spam bot, or that a bag of white powder hasn't been swapped out by a crooked cop, or that a contract wasn't photoshopped by a bitter ex-business partner.
And we have a ton to cover. We're going to look at tangible evidence, the stuff you can actually touch. We'll get deep into authentication, which is the whole process of proving an item is what you say it is.
And we'll also talk about the famous best evidence rule, which, this blew my mind when I learned it today, isn't actually about having the best evidence.
It is, hands down, the most confusingly named rule in the entire legal canon. We will clear that up. And we'll wrap things up with the parol evidence rule, which changes how we look at contracts, and then finally, demonstrative evidence, experiments in the courtroom.
Oh, I love a good courtroom experiment. Now look, I know federal rules of evidence sounds like the cure for insomnia, but I promise you, listener, this is really the toolkit for figuring out the truth. And we're going to keep it in plain English. No Latin, unless it's absolutely necessary to sound fancy.
And even then, we'll translate.
It's a deal. So let's start at the beginning. Tangible evidence. What are we actually talking about here? When we say tangible, does that just mean solid?
Well, tangible evidence is quite literally evidence you can perceive with your senses, mainly touch and sight. It's the opposite of oral testimony. Oral testimony is just a person sitting in a chair, moving their lips and making sounds. Tangible evidence is a thing.
Right.
And broadly speaking, it falls into two big buckets.
Buckets of evidence. I like that. What's in bucket number one?
So first, you have your physical objects. This is what we call real evidence.
Like the rusty revolver I was talking about.
Right. Guns, torn clothing, a bag of drugs, an injured foot, a broken car bumper. If it's a physical object that actually played a role in the events of the case, it's in this bucket. It's the stuff of the crime or the accident itself.
Okay, so that's all the physical stuff. What's the second bucket?
The second bucket is documentary evidence.
Which is paper.
Usually, yeah.
Yeah.
Written contracts, letters, wills, deeds. But in the modern era, we've had to expand our definition of document. This now includes digital files, sound recordings, emails, text messages, even just data on a hard drive.
So a tweet is a document.
For the purposes of evidence, yeah. It absolutely is. It's a record of a communication.
Okay, so we have our object. Let's say I'm a lawyer and I've got a pocket watch. A very nice antique pocket watch with a gold chain. I claim this watch was stolen from my client, and we found it in the defendant's apartment. I want to show it to the jury to prove he stole it. Can I just, hand it to the jury foreman and say, hey, check this out?
Absolutely not. If you try to do that, the defense attorney will scream, objection, before you even get halfway to the jury box. Before that watch gets anywhere near the jury, you have to cross the first major hurdle. Authentication.
Authentication. It sounds like something I do when I log into my bank account and I have to find all the pictures with traffic lights.
It's a similar principle, actually. Authentication is all about verifying identity. The rule is simple, but it's very strict. All tangible evidence must be authenticated. To do that, the proponent, that's the person trying to introduce the evidence, so in this case, you must produce sufficient evidence to support a finding that the item is what the proponent claims it is.
Support a finding. It sounds kind of vague. This is what always gets me about the law. It's so slippery. How sure does the judge have to be? Like, 100% certain this is the watch.
No, and that's a crucial point that trips up a lot of people. The standard of proof for authentication is actually pretty low. It's much lower than the standard for winning a civil case. That's preponderance of the evidence. And it's vastly lower than for a criminal conviction, which is beyond a reasonable doubt.
Really? So the judge doesn't even have to be convinced.
The judge does not have to be convinced that the watch is definitely your client's. The judge just has to be convinced that a reasonable jury could find that it's your client's watch.
That seems like such a weird distinction.
Well, think of the judge as a bouncer at a club. The bouncer isn't there to decide if you're the best dancer in the world. He's just deciding if you have a ticket to get in. The judge is the gatekeeper. They just ask, is there enough evidence here that a rational person might believe this is the real watch? If the answer is yes, the watch gets in.
So the bar is basically set at, yeah, that looks like it might be it.
Pretty much, yeah. It's what's called a prima facie showing.
Yeah.
But, and here's the so what factor, just because a judge lets it in, that doesn't mean it's the gospel truth.
Right. So just because the judge says, okay, you can show the watch, that doesn't mean the jury has to believe me.
Exactly. Admission doesn't stop the opponent from challenging it. The judge lets the watch in, but then the defense lawyer can stand up during cross-examination and say, ladies and gentlemen of the jury, look closely at that watch. The plaintiff says it's an antique. I say it's a cheap knockoff from a street vendor. Look at the plastic casing.
So the judge decides if it can be seen, and then the jury decides if it's real or fake.
Precisely. It becomes a question of weight, not admissibility. The jury weighs the truth of the object.
Okay, let's unpack how we actually do this. How do we authenticate stuff? Let's stick with my stolen pocket watch scenario. My client is on the stand. I hold up the watch. What does my client say to get it past the bouncer?
This is the simplest method, personal knowledge. The witness simply looks the object and testifies based on their memory. They'd say, yes, that is my pocket watch that was stolen.
That's it. They just say, yep, that's mine.
Well, if the object is unique enough, yes. But usually, you need to point out why you know it. They'd say something like, I recognize it because it has my initials, HS, engraved on the back, and there's a deep scratch near the winder where I dropped it back in '99.
Ah, okay. So distinctive markings really matter. If they just said, it looks like a watch, that might not be enough.
Correct. It needs to be recognizable to them personally.
Okay, but what if it's not a physical object? What if it's a digital file? Let's say a Word document found on a laptop. I can't exactly say, yes, I recognize the pixels. You know, pixels are pixels.
Right. And this brings us to the second method, distinctive characteristics. You look for unique identifiers. For a digital file, you're looking at metadata.
Metadata, so the data about the data.
Correct. Every time you create a file, the computer is secretly keeping a log. It records the creation date, the last modified date, the author name that's registered to the software, and sometimes even the GPS location.
So I don't need the author to stand up and say, I wrote this.
Nope. You can authenticate it by circumstantial evidence. You could say, Your Honor, this file was found on the defendant's laptop. It's titled myevilplan.docs. The metadata shows it was created at 2 in the morning on the night of the crime, and the author field lists the defendant's nickname.
So the computer leaves a digital fingerprint.
Precisely. And that combination of factors, the location, the file name, the metadata, is enough for the distinctive characteristics test.
Okay, now let's make it harder. What if the evidence isn't unique? What if it's, I don't know, a vial of blood, or a bag of white cocaine powder, or a generic 9mm casing? One vial of red liquid looks exactly like another. I can't look at it and say, oh yeah, that's my blood. I recognize the shade of red. It's a vintage O positive.
And this is where things get really tricky, and where TV shows often get it wrong. For generic items that are fungible, meaning one looks just like another and they're interchangeable, or items that are prone to tampering, you can't use personal knowledge. You need the chain of custody.
The chain of custody, that sounds ominous. It sounds like a medieval torture device.
It's the ironclad logbook of the law. Because you can't identify the object by sight, you have to identify it by its history. You have to account for the whereabouts of that item from the very moment it was collected until the moment it appears in court.
Every single moment, like literally every minute.
Every link in the chain. Think about it. The officer who collected the blood sample testifies, I drew the blood at 10 p.m., put it in a vial, labeled it, and sealed it in a bag. Then the evidence clerk testifies, I received that sealed bag at 10:30, I signed for it, and put it in the locked fridge. Then the lab tech testifies, I took it out of the fridge at 8 a.m. the next day, and the seal was unbroken.
Okay, but let's play devil's advocate here. What if the guy at the front desk forgot to sign the logbook? Or what if the bag was just left on a desk for an hour while everyone went to Chipotle for lunch?
That is a break in the chain, and this is where the defense attorney earns their paycheck. If there's a 1-hour gap where that bag was just sitting on a desk, unmonitored, the chain of custody is compromised.
Does the evidence get thrown out automatically?
Not always automatically, but the defense will create a narrative of doubt. They won't just say, you broke the rules. They'll say, ladies and gentlemen, for 60 minutes, nobody knew where that blood was. Who walked by that desk? Was it a janitor? Was it a rival officer? Was it the real killer planting evidence? We just don't know.
Ooh, I see. The law abhors a vacuum. So if you leave a gap in time, the defense is allowed to fill it with paranoia.
Exactly. If the break is bad enough, like if the evidence was missing for a week or something, the judge might rule that the authentication failed and throw it out completely. But usually it goes to the jury, and the jury might just decide the evidence is worthless because of that lunch break.
So for a pocket watch, I just need to say, that's mine. But for a blood sample, I need a flawless paper trail of everyone who ever breathed on it.
That's the trade-off. The less distinctive the object, the stricter the process to prove it's real.
Okay, let's move on. We've talked about objects. What about photos? We see photos in court all the time. Crime scene photos, car crash photos. I mean, in the age of Instagram, everyone's a photographer. Do I need to find the person who actually clicked the shutter to authenticate a photo?
Surprisingly, usually no. This is a very common point of confusion. You generally do not need the photographer.
Really? That seems totally counterintuitive. Who authenticates it then?
You just need a witness with personal knowledge of the scene depicted in the photo. Let's say you took a photo of an intersection after a nasty car crash. I wasn't the photographer. I was just standing on the corner, waiting for the bus, watching the whole thing happen. You can put me on the stand, show me the photo, and ask, does this look like the crash?
And you just say yes.
I'd say yes, this photo is a fair and accurate representation of the intersection as it appeared on that day.
Is that the magic phrase? Fair and accurate representation.
That is the magic phrase. The photo is treated as a visual aid to my testimony. I am the evidence. The photo is just illustrating what I saw.
But wait a minute. We live in the era of Photoshop. We live in the era of AI. What if I took that photo and edited it? What if I made the traffic light red instead of green?
And that's where the witness comes in. If you show me a photo where the light is red, but I remember it being green, I'll say, no, this is not a fair and accurate representation, and then the photo doesn't get authenticated through me.
But what if the edit is really subtle? Or what if I used a deepfake to generate a whole new scene?
This is the terrifying frontier of evidence law. The fair and accurate standard relies on human memory, which we all know is fallible. If a deep fake is convincing enough, a witness might honestly think it looks right. Yeah, that looks like the guy. Currently, the rules treat deepfakes just like any other photo. If a witness vouches for it, it gets in. But this is becoming a massive, massive problem.
We'll have to come back to that nightmare scenario later. But for now, there's an exception to this I recognize the scene rule, right? X-rays.
Yes. And think about the difference between a photo of a car and an X-ray of a broken rib. You can look at the car and verify it with your own eyes. You cannot verify an X-ray with your naked eye.
Right. I can't look at a gray smudge on a film and say, oh yeah, that is definitely my femur. I recognize the curvature. Unless I have X-ray vision, which I don't.
Since the law assumes witnesses are not Superman, the standard has to change. You can't rely on a witness saying, it looks like my lung. Instead, you have to authenticate the process.
So we're putting the machine on trial.
In a way, yeah. This is sometimes called the silent witness theory, since no human actually saw the bone inside the body. The image itself is the witness. And to let it speak, you have to prove that the X-ray machine was working properly, that the process used to take the image was standard and accurate, and that the operator was qualified.
And I'm guessing our old friend chain of custody shows up here too.
Oh, absolutely. You have to prove that this X-ray file belongs to patient A and wasn't mixed up with patient B in the hospital database.
That makes perfect sense. With a photo, I verify the content. With an X-ray, I verify the technology.
You got it.
All right, let's do a quick recap of where we are. We're building our evidence toolkit.
Right. So far, we know that tangible evidence is anything physical or documentary.
And before the jury sees it, we have to authenticate it. The bouncer has to let it in.
If it's a unique object, like a watch, personal knowledge works. That's mine.
But if it's generic, or messy, like blood, we need the chain of custody, every minute accounted for. No lunch breaks without paperwork.
For photos, we just need someone to say, that's a fair representation of the scene. But for x-rays, we need to prove the machine and the process were sound.
Got it.
Mhm.
Now let's shift gears a bit. We're moving from physical objects to documents, paper trails. And we're starting with something that sounds like it belongs in an Indiana Jones movie. Ancient documents.
I love this rule. And it feels very old school, very 19th century. The law has a special carved out rule for documents that are just old.
How old is ancient in the eyes of the law? Are we talking Dead Sea Scrolls, the Magna Carta?
Believe it or not, the threshold is just 20 years.
Wait, hang on. 20 years? That seems dangerously short. I have t-shirts older than 20 years. My college diploma is an ancient document.
In the rapid pace of the modern world, yeah, 20 years is considered a long time for a piece of paper to survive. The ancient document rule says that a document is automatically considered authentic if it meets 3 criteria.
Okay, let's hear them. But I'm still skeptical about this 20-year thing.
First, as we said, it must be at least 20 years old. Second, it must be in a condition that doesn't create suspicion.
Meaning no eraser marks or, it wasn't clearly written yesterday with a ballpoint pen?
Exactly. If the paper is crinkled and yellowed, but the ink looks bright blue and wet, that's suspicious. If pages are missing, or if the font looks like it was printed on a laser printer when it should have been a typewriter, the rule doesn't apply. It has to look its age.
Okay, age and condition. What's the third?
Third is location. It must be found in a place where you would expect to find it.
Like a deed in a safe deposit box.
Exactly. Or an old love letter in a shoebox in the attic. Or a business ledger in the company archives. If you find a 20-year-old will underneath a potted plant in a stranger's house, that's suspicious. That doesn't fit the pattern of where a will should be, but if you find it in a filing cabinet labeled wills, that fits.
So if you hit those 3: age, condition, location, the court just assumes it's real without needing a witness to testify about it.
Correct.
But let me push back on this. What if I forged a document back in 2005? I used old paper, I used an old typewriter, and I threw it in my basement to let it get dusty. Now it's 2026. It's over 20 years old. It looks real. It was found in my basement. Does the court just accept my forgery?
Theoretically, yes, for the purpose of authentication. But remember, authentication just means it gets to the jury. The opponent can still argue he forged this 20 years ago, but the law allows it in because finding a witness from 20 years ago, who might be dead, retired, or have moved to the Bahamas, is considered too burdensome. It's a rule of necessity, really.
I guess that makes sense. We can't be chasing ghosts for every single piece of paper.
Yeah.
Okay, what's next in the document world? The reply letter doctrine. This sounds like something from a Victorian novel.
It does, but it applies to emails too. So imagine you send a letter or an email to someone, let's call him Bob, asking about a specific shipment of widgets. Dear Bob, where are the red widgets? A week later, you get a letter back signed Bob that says, yes, the red widgets were shipped on Tuesday.
Okay.
How do you know Bob actually wrote that? Anyone could sign Bob. Maybe Bob's assistant wrote it. Maybe a hacker wrote it.
Sure.
The reply letter doctrine uses what I call ping-pong logic. If the reply contains information that is likely only known by the person who received the first letter, or if it's responsive to the specific question you asked, we treat it as authenticated.
Because I served the ball to Bob and the ball came back from Bob's side of the table, so I can assume Bob hit it.
That is a perfect analogy. Unless someone intercepted your mail, read it, and forged a reply, which is, pretty unlikely, we assume the reply is genuine.
Now, let's talk about handwriting. This is the classic courtroom drama moment. The expert puts on the little glasses and looks at the loop on the Y.
Right. Handwriting verification is a staple of the law. And there are 2 main ways to do it, and it's really critical to understand the difference. First, there's the expert method. You hire a forensic document examiner,
Tro.
the pro. They take the question document, the potential forgery, and compare it to a known genuine sample, like a tax return or a driver's license signature. They analyze stroke width, pressure, angles, all of it.
And the jury could do this too, right? I heard that.
Yes. The trier of fact, the jury or the judge, can actually look at the 2 samples side by side and decide for themselves. They don't have to rely on the expert. It's essentially arts and crafts time for the jury.
I love that. But what if we don't have an expert? Can I just say, hey, I know Bob's handwriting and that looks like it?
You can, but this is the non-expert opinion method, and there is a massive trap here. A regular person, a lay witness, can testify. That's Bob's handwriting. But They must be familiar with the handwriting from before the lawsuit started.
Ah, so I can't cram for the test?
Yeah.
I can't study Bob's handwriting just to testify?
No. That is strictly forbidden. An expert can study it for the trial. A lay witness must have prior knowledge.
Let's role play this to make it stick. Let's say Uncle Joe dies. He's rich. Suddenly, the creepy neighbor shows up with a napkin that says, "I leave all my millions to the neighbor." Signed, Uncle Joe.
Okay.
I'm Uncle Joe's niece. I want to testify that the signature is a fake. I've been getting birthday cards from Uncle Joe for 30 years. Can I testify?
Yes, you have prior personal knowledge. You are a lay witness. You can look at that napkin and say, that is not how Uncle Joe makes his J's.
Okay. Now, imagine my husband wants to help. He's never seen Uncle Joe's writing. Can he spend all night looking at Uncle Joe's old checks and then testify the next day?
Absolutely not. He is a lay witness. He cannot acquire the knowledge for the purpose of litigation. Only a qualified expert is allowed to study for the test.
That is a huge distinction. Lay people need old knowledge. Experts can get new knowledge.
Correct.
Okay, moving on. We've been talking about how hard it is to authenticate things, but surely there have to be some things that are just obviously real. Is there an easy button?
There is. We call these self-authenticating documents. These are the VIPs of evidence law. They get to skip the line. You don't need a witness to stand up and say, this is real. They prove themselves.
I like the sound of this. Who's on the VIP list?
Newspapers and periodicals. If you bring in a copy of the New York Times, you don't need to subpoena the editor-in-chief to prove it's a newspaper. The court just accepts it.
Makes sense. It would be a huge hassle to call the newspaper for every single defamation case.
Also on the list are trade inscriptions. This just means labels on products. If you have a can of soda that says Coca-Cola on it or a box that says Made in USA, the court accepts that it is what the label says it is.
Wow. Imagine if you didn't have that rule. You'd have to find the guy at the canning factory. Sir, did you manufacture this specific can on this specific Tuesday? I don't know, I made 1 million of them.
It would be impossible. The law recognizes that commercial labels are generally trustworthy enough to just let them in. Other items on the list include notarized documents. That little stamp carries a lot of weight in certified public records. If it has the official seal of the court or the government, it gets in.
What about business records? I feel like those must be huge in corporate lawsuits.
They are. Records of regularly conducted activity, like bank statements, shipping logs, employee timesheets, can be self-authenticating if they're certified by a custodian. But there is a gotcha here.
There's always a catch.
You can just spring these on the other side. You must give the opponent reasonable written notice before the trial. You have to tell them, hey, I'm using these bank records, so they have a fair chance to inspect them and challenge them if they want. You can't ambush someone with a mountain of spreadsheets at the last second.
Ambush by spreadsheet sounds like the worst way to die.
It is a painful legal death, for sure.
Okay, let's slide into oral statements. Voices and phones. We talked about handwriting, but what about hearing a voice? Say we have a recording of a ransom call. Who can identify the voice?
This rule is fascinating because it is so much looser than the handwriting rule. For voice identification, any person who has heard the voice at any time can identify it.
Wait, any time, even if they just heard it yesterday for the first time?
Yes. Remember how with handwriting, your husband couldn't study the checks?
Right.
With voices, he can. Your husband could listen to a recording of the suspect speaking, or even just listen to the suspect talk in the hallway 5 minutes before taking the stand, and then testify. Yes, that is the voice on the ransom tape.
That is wild. Why the difference? Why is the law so strict on handwriting but so loose on voices?
The theory is that humans are just naturally evolved to recognize voices quickly and accurately. We pick up on timbre, tone, cadence almost instantly. Handwriting is an artificial skill. It requires more study. Now, whether that science holds up is debatable, but that is the rule.
That is really interesting. So what about telephone conversations? This is classic noir stuff. I call a number, someone answers. How do I prove who I was talking to?
It depends on who called whom. If you made the call, an outgoing call, you can authenticate the identity of the person who answered in a few ways.
Okay.
If you dialed a specific person's number that's listed in the directory, and the person who answered identified themselves, hello, this is Steve, that's usually enough.
Hello, Steve speaking. Simple.
Or if you dialed a business and the person who answered spoke about business matters related to that company, that authenticates that you called that business.
So if I call Joe's Pizza and the guy on the other end answers and takes my pepperoni order, I can assume I called Joe's Pizza. I don't need him to say, I am the owner of Joe's Pizza.
Exactly. The context authenticates it. But what about incoming calls? or cases where the person doesn't identify themselves. Then you look at the content. If the speaker knows facts that only that specific person would know, that authenticates their identity.
The secret knowledge test, like, I know what you did last summer.
Precisely. If the voice on the phone says, "I buried the gold bars under the old oak tree at midnight," and only one person in the world knew about the gold bars, well, that's pretty good authentication that it's him.
All right, let's take a breath here. We've covered a ton. Let's do a quick recap before we hit the big monster of this deep dive.
Good idea.
Ancient documents. 20 years old, good condition, right place equals authentic. But watch out for 20-year-old forgeries.
Correct. No witness needed for those.
Handwriting. Regular people need to know it beforehand, like Uncle Joe's niece. Experts can cram for the test.
But voices, anyone can ID a voice, even if they just learned it 5 minutes ago.
Self-authenticating docs. The VIPs.
Yeah.
Newspapers, Coke cans, notarized documents. No witness needed.
And business records get in too, as long as you give that written notice. No ambushes.
You are doing great, listener. We're halfway through the obstacle course. Now, we are going to hit one of the most famous and most misunderstood rules in all of law. The best evidence rule.
Ah, yes. The best evidence rule. The name is just terribly, terribly misleading. It sounds like it means you have to bring the best possible evidence you have.
Right. Like if you have a video of the crime, you shouldn't just bring a blurry photo. The video is better.
That is what everyone thinks it means, but it is flat out wrong. It does not mean you have to present the most persuasive evidence. You could have a 4K IMAX video of a crime, but you could still choose to just put an eyewitness on the stand instead. The best evidence rule wouldn't stop you.
Okay, so if it's not about quality, what is it about?
It's more accurately called the original document rule. It dates back to the 1700s, to the days of scriveners and copying clerks.
Guys with quill pens and powdered wigs.
Exactly. Back then, if you copied a document by hand, you were bound to make mistakes. You dropped words, you spilled ink. So the courts developed a rule. If you are trying to prove the contents of a writing, you must produce the original writing. You can't just bring a copy or tell us what it said.
Prove the contents. That sounds like the key phrase here.
It is. And remember, writing is a broad term. It includes recordings, x-rays, videos, data.
So when does this rule kick in? This is where it gets tricky for me.
Right.
We need to figure out when the contents are at issue.
There are 3 main triggers. Trigger 1. The document acts as proof that an event happened. Think of a photo of a bank robbery. The photo is the proof of the robbery. Or a defamation case. The libelous letter is the crime itself.
Okay, trigger 2.
Trigger 2. The document has a legal effect, a contract, a will, a divorce decree. The words on the paper create the legal reality. You can't just testify about the will. The will itself is the thing that matters.
And trigger 3.
Trigger 3. The witness is testifying only based on what they read in the document, not from their own personal knowledge.
Okay, let's play a game. I'm going to give you scenarios, and you tell me if the best evidence rule applies.
I'm ready.
Scenario A. I'm walking down the street. I see a car run a red light and crash into a bus. I go home, and I write all about it in my diary.
Okay.
At trial, the lawyer asked me, "What did you see?" Can I answer? Or do I need to bring my diary because I wrote it down?
You can absolutely answer. The best evidence rule does not apply. Why? Because you saw the crash with your own eyes, you have personal knowledge, the diary is just something you wrote later, you're not trying to prove the contents of the diary, you're proving the fact of the crash. And the fact exists independently of the writing.
Okay, good. Scenario B. I sign a lease for an apartment. The lease says, no pets allowed. Later, I get evicted for having a tiger.
A tiger.
It's a hypothetical tiger. It's a very polite tiger. So I go to court and say, Your Honor, the lease said tigers were fine. The landlord says, no, it didn't.
Okay, now, the best evidence rule does apply. Why? Because the rights and duties, the legal effect, lives in the paper. Your memory of the lease doesn't matter. The actual words on the page matter. To prove the terms, which are the contents, you must produce the original lease.
Got it. Okay, scenario C. A witness testifies, I know the bank balance was exactly $10,000 because I looked at the bank statement.
Best evidence rule applies. The witness has no personal knowledge of the actual money in the vault. They only know what the document said. Therefore, they're proving the contents of the document. You need the bank statement itself.
This is starting to click. So if I saw the world, I can talk about the world. But if I only saw the paper, I need to bring the paper.
That is a perfect summary.
So what counts as an original these days? We live in a digital world. If I take a screenshot of a text message, is the screenshot the original?
That's a hot topic. Technically, the data on the server is the original, but the law has adapted. A computer printout counts as an original. A photo negative counts as an original.
What about photocopies or scan?
Those are called duplicates. And generally, duplicates are admissible to the same extent as an original. If you bring a Xerox of the contract, the court usually accepts it. The days of fearing the scrivener's error are mostly gone because Xerox machines don't make typos. Unless there's a genuine question about authenticity. If you bring a photocopy and the other side says, hey, I think you photoshopped this copy, then you might be forced to produce the original. Or if it would be unfair, like if you only photocopied the bottom half of the page and hid the fine print.
That makes sense. But here's one that surprised me. Handwritten copies. Say I lost the lease, but I hand-copied it word for word onto a napkin.
Stop right there. A handwritten copy is not a duplicate. It's considered secondary evidence. Why? Because human error is back in play. You might have copied it wrong. You might have skipped a knot. Because a human hand intervened, it's treated with much more suspicion than a machine copy.
So photocopies are good. Handwritten copies are a last resort. Speaking of last resort, what happens if the original is gone? The dog really did eat the contract. Or the building burned down. Or the file was corrupted. Am I just out of luck?
Not necessarily. The law is strict, but it's not heartless. You can excuse the non-production of the original.
How do you do that?
If you can prove that all originals are lost or destroyed, and crucially, that you didn't destroy them in bad faith, then you can use other evidence.
Bad faith, meaning I didn't burn the contract on purpose because I knew it made me look bad.
Right. If it was an accidental fire or a flood or you just lost it in a move, that's fine. You can then testify to what the contract said, or you can use that handwritten napkin copy. But if the judge thinks you shredded it to hide the truth, you are sunk.
What if the bad guy has the contract?
If the opponent has the original and refuses to produce it, even after you put them on notice, then you're excused. They can't hide the document and then claim best evidence rule to stop you from talking about it. That would be absurd.
Now, I want to ask about one specific strategy that lawyers use, the voluminous records problem.
Ah, the dump truck strategy.
Yeah. Say I want to prove that a company was embezzling money. I have 10,000 pages of bank records. Do I have to read every single transaction to the jury? They'll fall asleep. The judge will fall asleep.
And everyone will hate you. No, for voluminous records, you're allowed to present a summary, a chart, or a calculation. Ladies and gentlemen, here is a pie chart showing where the money went.
Thank goodness for that.
But there is a condition. You can use the summary in court, but you must make the originals available to the other side beforehand.
You have to let them check your math.
Exactly. You can't just make up a chart. You have to say, here's the chart, and the 10,000 pages are in the conference room if you want to audit them. Transparency is the price of the shortcut.
Before we leave the best evidence rule, I found this judge versus jury split interesting. Who decides if the excuse is good enough?
It's a classic division of labor. The judge usually decides the legal excuses. Is the excuse for missing the original valid? Was the search diligent? Was it bad faith? The judge is the referee of the rules.
And the jury?
The jury decides the factual truth. Did the original document ever actually exist? Is this secondary evidence accurate? The judge sets the field. The jury decides who scored the points.
Recap time. Let's lock this in.
Best evidence rule equals produce the original if you're proving the contents of a document.
But it does not apply if you saw the event with your own eyes. Personal knowledge trumps the paper.
Duplicates like photocopies are generally fine. Handwritten copies are not duplicates. They are a fallback.
And if the original is lost, and not by your own bad faith, you can use other methods to prove what it said.
Perfect.
Okay, we are in the home stretch. Section 8, the parole evidence rule. This is contract law, isn't it?
It is. We're stepping out of the pure evidence world and into the world of agreements. The parole evidence rule is all about keeping the deal.
The deal. And parole here doesn't mean getting out of jail early. It comes from the French for word or speech, right?
Correct. The basic philosophy here is the four corners doctrine. If two parties sit down and write a contract that is intended to be their complete agreement, the court wants to stay inside the four corners of that paper.
So the rule is, if we signed it, we meant it.
Basically. The rule says you cannot introduce extrinsic evidence stuff from outside the contract, like oral conversations, emails, or handshake deals made before the signing to contradict or change the terms of the written deal.
So if the contract says price, $100, I can't bring in a witness to say, but before we signed, he told me the price would be $80.
Exactly. The court looks at the written document and says, this is what you signed, this is the deal. The goal is to prevent people from lying about side deals that undercut the written contract. It creates certainty.
This concept of integration comes up. It sounds like calculus. What does it mean in contracts?
Integration is just a fancy way of asking, is this contract finished? Complete integration means the document has everything. It usually has a clause at the bottom called a merger clause that says, this agreement supersedes all prior agreements. If it's completely integrated, no outside evidence is allowed to add or change terms. The door is locked.
And partial integration.
That means the writing was intended to be final for some terms, but not all of them. Maybe it lists the price, but doesn't list the delivery date. In that case, you can bring in outside evidence to fill in the gaps with consistent terms, but you still cannot contradict what is written.
So if it's partial, I can say, we agreed on a Friday delivery because the contract is silent on delivery. But I still can't say we agreed on $80 if the paper says 100.
Precisely. You can add to the story, but you can't rewrite the chapters that are already written.
Now, every rule has exceptions. And I know there's a famous case about chickens that explains one of these exceptions.
Ah, the Frigolament case. The what is chicken case.
Yeah.
This is a law school legend.
Tell us the story.
So, a Swiss company buys chickens from an American company. The contract just says chicken. The Swiss company thinks chicken means young, tender birds suitable for broiling and frying. The American company sends them stewing hens, old, tough birds that you boil for soup.
Yikes.
The Swiss company sues, you sent us bad chicken. The American company says, hey, the contract said chicken. These are chickens, they have feathers, they cluck, deal with it.
So the parole evidence rule would normally say, look at the paper, but the paper just says chicken. It's ambiguous.
Exactly. And this is the ambiguity exception. If a term in the contract is unclear, you can bring in outside evidence to explain what the parties meant. They had to look at Department of Agriculture standards, market prices, and even the German word for chicken used in the negotiations to figure out what chicken actually meant.
So if the word is clear, like $100, no outside evidence. If the word is fuzzy, like chicken, outside evidence is allowed.
You got it.
What are the other big exceptions?
Fraud, duress, or mistake. If you held a gun to my head to make me sign, I can introduce evidence of the gun. The parole evidence rule doesn't protect a contract signed under threat. Or if I tricked you into signing by swapping the pages.
A trade custom.
Right. If everyone in the industry knows that a baker's dozen means 13, I can bring in evidence of that custom to explain the term, even if the dictionary says a dozen is 12.
Here's the most important timeline question for me. Does this rule block everything we ever said to each other?
No. And this is the biggest trap for law students. The parole evidence rule only blocks negotiations from before or during the signing.
What about after?
It does not block agreements made after the contract was signed. Those are called modifications. If we sign the contract on Monday and on Tuesday we agree to change the price, I can bring in evidence of that Tuesday conversation. The rule assumes the written contract captured our intent at the moment of signing, but it doesn't stop us from changing our minds later.
That's a crucial distinction. Pre-signing talk is blocked. Post-signing talk is allowed.
You've got it.
Finally, last section, demonstrative evidence. This is the show and tell portion of the trial.
It is. This covers experiments, exhibitions, and visualizations performed right there in the courtroom. This is where lawyers get theatrical.
Like when a personal injury lawyer wants the plaintiff to show their injured leg to the jury?
Yes. Generally, a plaintiff is allowed to exhibit their injuries to show the extent of the damage. But there is a limit. The court can stop it if it creates unfair prejudice.
Meaning it's just too gruesome.
Exactly. If showing the injury would just horrify the jury, make them vomit, or make them decide the case based on pure emotion rather than facts, the judge might say, no, we'll use a medical diagram instead. The probative value, how useful it is, has to outweigh the prejudicial effect, how much it biases the jury emotionally.
And experiments. I'm picturing a scientist mixing chemicals on the judge's bench to prove a reaction.
Science experiments are permitted, but again, the judge has discretion. If the experiment is going to take 3 hours, create a noxious smell, or just confuse the jury more than it helps, the judge will say no.
Objection, Your Honor. The volcano experiment is getting lava on the defense table.
Sustained. And the experiment must be substantially similar to the actual conditions of the event. If you're testing the stopping distance of a car, you can't do it on a dry road if the accident happened on a wet road.
All right, we've reached the end of the roadmap. We've covered tangible evidence, authentication, best evidence, parole evidence, and demonstrative evidence.
It's a lot, but think about the story we've told here.
We started with a gun on a table. We learned that you have to prove it's the gun through authentication. And if it's generic, like blood, you need a chain of custody to prevent that narrative of doubt.
Then we learned that if you want to prove what a contract says, you need the contract itself. That's the best evidence rule. You can't just rely on your memory of it.
And once you have that contract, you generally can't use side conversations to change it, thanks to the parole evidence rule. Unless, of course, you're arguing about what chicken means.
These rules aren't just red tape, they're filters. They're designed to keep the jury focused on reliable facts. They stop rumors, they stop guesses, and they stop fake documents from hijacking the truth.
It really makes you look at the news differently. When you hear sources say or see a leaked document, you start to realize how incredibly hard it would be to actually get that into a court of law.
Absolutely.
But
The court is a sealed environment where truth has to be proven, not just asserted.
So here's my final thought, and I want to leave the listener with this because we touched on it earlier. We talked about ancient documents being only 20 years old. We talked about voice ID being valid if anyone recognizes the voice.
Yes.
In a world of deepfakes and AI, are these rules doomed? If an AI can perfectly mimic my voice, and anyone who has heard me can testify it's me, isn't that a recipe for disaster? And if an AI can generate a perfect aged document that looks 20 years old, does the 20-year rule even hold up?
That is the billion-dollar question. The federal rules of evidence were built for a physical world, a world of paper and ink and distinct human voices. As the line between real and synthetic just blurs, the law is going to face a massive crisis of authentication. We are already seeing the deep fake defense, people claiming real videos are fake.
And people claiming fake videos are real.
Exactly. We might need a whole new digital evidence rule that's much stricter than what we have now, perhaps relying on cryptographic signatures or even blockchain for the chain of custody. The chain of custody might move from a paper logbook to a digital ledger.
The law is always playing catch-up to technology. But for now, you, the listener, are equipped with a toolkit as it stands today. You know your hearsay from your hearsay exceptions. Wait, we didn't even touch hearsay. That's for another deep dive.
Oh, that's a whole other deep dive. Hearsay is a beast.
For today, though, you know how to prove the paper trail.
Thanks for diving deep with us.
See you next time.